If you are thinking about making a big move with your child and you have custody agreements in place, then you need to watch this to understand what can and cannot happen in Oregon and Washington. I have seen parents make this decision thinking they were doing what is best, only to end up in court being told they have to bring their child back. Hi, I'm Lewis Landerholm, family law attorney and partner here at Pacific Cascade Legal. One of the most common and emotional conversations I have with parents is about moving with their child. Sometimes it is a job opportunity, sometimes it is to be closer to family, sometimes it is just feeling that a fresh start would be better for everyone. And all of those reasons can be valid, but what many people do not realize is that this is not just a personal decision, it is a legal one. Let me walk you through a situation I see all the time. A parent gets an opportunity, feels like the right move for them and for their child. They start planning, maybe even packing, thinking this is clearly a better situation. So they move forward without really thinking about the legal side, then everything changes. The other parent finds out and objects. Now there is a court case, everything slows down. Emotions are high, and in some situations, the judge orders the child to be returned. Not because the move was a bad idea, but because the process was not followed. In both Oregon and Washington, you can move with your child, but there are very specific steps you have to take first. The first step is giving proper notice. In most cases, this means formal written notice anywhere from 30 to 60 days before the move. In Oregon, this is required and especially important if you are moving more than 60 miles farther away from the other parent. In Washington, notice is typically required if the move is going to impact things like the child's school or the current parenting schedule. And this isn't something informal. It is not a quick text or a conversation. It needs to be done the right way. The next piece is that the other parent has the right to potentially object. In Washington, they generally have 30 days to file the objection after receiving notice. If they do object, the move does not just happen. The court gets involved and a judge will step in and make the decision. And this is where everything centers around your child. The court is going to look closely at what is in your child's best interest. They will consider why you want to move, how it affects your child's day-to-day life, their school, their routine, and their relationship with the other parent. It is not just about whether the move makes sense for you, it has to make sense and be in the best interest of your child in a bigger picture way. The difficult part is that even when your intentions are good, skipping the legal steps can create serious consequences even if you have legal custody. A judge can order the child to be returned, you could lose parenting time. In some cases, there can even be findings of contempt. So if you are thinking about moving, the most important thing you can do is pause and plan. Do not make the move first and figure it out later. Take the time to understand what is required. Give proper notice and be prepared for how the other parent might respond. When this is handled the right way, relocation can be approved, but it needs to be done carefully and thoughtfully. If you are considering a move with your child, this is one of those moments where getting guidance early can make a big difference. At Pacific Cascade Legal, we help parents walk through these decisions step by step so they can protect their relationship with their child and avoid unnecessary setbacks. If you are in this situation, reach out to us and schedule a consultation. We can help you understand your options and create a plan that works for you and your child.